Mr. Morales, I think that's all the business we have for you at this time.
Thank you, Honor. Have a great day.
You as well. Sir Azula. Mr. Azula, you have a number of cases with us this morning. The first is you were arrested pursuant to an arrest warrant in 2020.
Sorry, sir. You started. I'm sorry. I need to hear everything they said.
Yeah, not a problem. Mr. Azula, you have a number of cases with us for initial appearance today, and I'm going to give you some information about each of those.
Yes, sir.
The first is in 2022, CF 10996. That allegation was pursuant to a warrant.
I got a question.
Hold on just a sec. I haven't even got very far, Mr. Azula. I'll give you a chance to talk to your attorney, and then if you need to talk to me, I'll certainly give you an opportunity. This was an allegation of burglary of a structure, criminal mischief, and resisting an officer without violence.
That's the misdemeanor?
This is a warrant.
That's the arrest warrant case.
Can I plea out to that today, sir?
You're going to have to stop interrupting me so I can get through all of this, and then we'll have a discussion about what to do with your case, okay?
Yes, sir.
All right. I don't know why this is in here because I got nothing attached to this. It goes with, got it. All right, that's the case that you are already out on bond for. So we'll talk about that one in a minute. The new case, or one of the new cases, is 2022 CF 11194. That has 7 allegations. Allegation 1 is carjacking with a weapon or a firearm. Count 2 is aggravated assault with a firearm. Count 3 is attempted homicide on a law enforcement officer. Count 4 is fleeing or attempting to elude a law enforcement officer with sirens and lights activated. Count 5 is driving while license suspended. Count 6 is trespass on school grounds or a facility. And count 7 is resisting an officer with violence with a weapon.
3 counts are on the back.
There's more counts. Count 8 is possession of a firearm by a convicted felon.
Sir, I never possessed.
Count 9 is home invasion robbery. If you're going to talk over to me, I'm going to do this in your absence. So
Oh, I'm sorry.
count 10 is reckless driving. Court finds probable cause for those allegations. Counts 1, 2, and 3, and 9 have no bond. Count 4 is going to be a bond in the amount of $5,000. Count 4 is going to be a bond of $5,000. Count 5 is going to be a bond in the amount of $2,500. Count 6 is going to be set in the amount of $500. Count 7 in the amount of $500. Count 8 is going to be set in the amount of $3,500. And count 10 will be set in the amount of $500. I will appoint the Office of the Public Defender on the new case. There's also a separate count in 2022 CF 11061. That count was pursuant to an arrest warrant signed by Judge Sanders Morency. That count is an allegation of aggravated assault with a firearm. Judge Sanders Morency has already found probable cause for that allegation. Bond in this case is going to be set in the amount of $7,500 with the conditions that you not have any contact with the listed victim in this case, that you not possess any weapons or firearms, and that you must surrender any firearms within your possession within 24 hours of any release. You're also ordered not to return to the scene where this one is alleged to have occurred, and I'll give you that information.
Thank you, sir.
Sure. This was alleged to have occurred at the Quick Stop at 5100 North Lane, Orlando,
Oh, yes.
Florida. Okay. The next case that I have is 2022 CF 11188. That is an allegation that was alleged to have occurred and appears to be an additional count from the first case that we were talking about, which deals with an allegation of an interaction that you had with someone who was driving a Porsche Macan GTS.
Porsche Cayenne? Macon?
Macan is what it says. That allegation is kidnapping with a firearm.
Kidnapping.
There is probable cause for that allegation. Court will set no bond as to that count, and the court will appoint the office of the public defender. There's additional counts in 2022 CF 11187. Those allegations relate to an incident that occurred at the 7-Eleven on 124 West Pine Street. Those are allegations of aggravated assault with a firearm ×2. The court finds probable cause for those allegations. The court finds that no bond is appropriate based on you being a danger to the community. As you are already out on bond on case number 2022 MM5669 and 2022 MM6156.
The state's not gonna make an offer on any of those out-of-bond cases, Your Honor.
What's that?
The state is not making an offer to resolve the out-on-bond misdemeanor cases.
Understood.
Why not?
All right, there's also, what is 2022 CF
Give me 5 days in the
1099?
county jail for that charge, man. Those are
It's not
misdemeanors,
gonna matter,
man.
you don't have bond in the other
No,
cases.
I'm not worried about the new cases. I'm talking about that misdemeanor
I
stuff.
understand,
You
but
can give me
you can
5 days in
resolve
the
it
county
all.
jail for that, man.
She's not going to.
She's
so-
a state attorney. It's 5 days. It's a misdemeanor.
Okay, she's not going to do it, so you can resolve
What's
it
the
with
point of
everything
not
else.
giving me time for those days, man?
You're going to get
All right.
credit.
Looks like there's another warrant, Mr. Azula, that is on 2022 CF 10996. That is an allegation of burglary of a structure, criminal mischief, and resisting an officer without violence. Judge Sanders Morenci has found probable cause, issued bonds in those counts in the amount of $5,000, $2,000, and $500.
Your Honor?
Also, the special conditions that you not return. I'm going to appoint the Office of the Public Defender to represent your interest on all of these cases. It's going to take them a little while to untangle all of this.
Yes, sir. Yes,
And
I just have a question on the case number for the carjacking, aggravated assault, all with the 10 counts. What was that case number, Your Honor?
the case number on that was 2022 CF 11194.
11194, okay.
Yeah, bond is revoked on that.
And it looks like, Your Honor, in one of the out-on-bond cases, the 22 MM5669, my office has closed with the no information.
All right, which case is that?
The 22 MM5669,
All right, the state of Florida is indicating that they are not moving forward with prosecution as to the allegations of assault and disorderly conduct in 2022 MM5669, so the court will withdraw its order revoking bond on that case.
thank you, Your Honor.
All right, I think we addressed everything. It's going to take some time to sort this out, so that will complete our initial appearance today.
Excuse me, Your Honor. You mentioned that the bond was revoked for the MM06156AO. Are you setting a new bond or is it no bond?
Bond is revoked and set at none on the case that remains active.
I don't have time to write it all better. You're gonna have multiple attorneys.
That's it?
Yes, sir.
Your Honor, can I ask you something?
You're welcome to ask me something. Understand that you're being recorded and you got a number of serious allegations against you. Probably not be a good idea to talk about the facts of the case, but I'll hear you out.
This is not my, sorry. This is not my first time here, Your Honor, obviously, as you can tell. But I want you to understand, Your Honor, certain times in our lives, for our family members, there's certain things, if you're forced to do them, you'll do them.
I read the charging affidavit and I
No,
understand.
no. Can I speak first, Your Honor?
Yes, sir.
Then I'll let you speak. I don't mean to be rude or anything. I'm just being all the way respectful with you, Your Honor.
Yes, sir.
Okay? If I'm forced to do anything, you put me in a position where you tell me that somebody in my family's life is in danger if I don't get you a certain amount of cash at a certain time. I'm willing to go get Donald Trump out of the White House to make sure my mom stays alive. I'm willing to go find Saddam Hussein to make sure my dad stays alive. So I want you to know, Your Honor, I just got out of prison May 30th. I don't plan to go back to prison. I didn't jump out of prison rushing to go back.
Understood?
So when it's all said and done, when we all get down to the nitty gritty of what happened, what really happened, Your Honor, I want you to know that I told you I will go get Donald Trump out of his house if somebody tells me they're gonna kill my mom.
Understood.
Okay?
Understood. I got no reason to,
I don't have to say nothing else. I hope
Okay.
you understand what I'm saying, because all these charges mean something.
understood.
Somebody made me do this.
Understood.
My mom and my dad's safety.
You got good attorneys, and they're going to be taking a look at every angle of a potential
Everything.
defense
Make
for
sure
you.
they look at everything. Phone
Yes, sir.
call, text message, all of that. I want y'all to see everything that's been going on.
Provide them with as much information that you have so they can,
I only been out of prison 4 months. My son is 10 years old.
yes, sir.
And I didn't plan to be here with all these fucking charges, okay? I'm sorry for cussing, but it's got me mad because I'm doing something to save a family member.
I understand. I understand your position, and share that with your
I
attorneys.
have $100,000 to give nobody.
Right.
But I will go get it if it means my dad has to stay alive, okay?
Yes, sir.
Thank you, Your Honor.
Yes, sir. State of Florida versus Yancey Styles.
Yes, sir. Yes, sir.
Good morning, Mr. Styles.
Good morning, sir.
Mr. Styles is here with us based on an allegation that he failed to appear. Mr. Styles, I guess you had some kind of camping ticket or allegation, and you didn't show up for pretrial. That would have been on September 12th. The court revoked your release, but did get you a bond in the amount of $100. That's the lowest bond that they can give you. I will appoint the Office of the Public Defender to represent your interests, Ms. Lampier.
Yes, Your Honor. Mr. Styles and I spoke before court. He is currently homeless and disabled, so we would ask for ROR in this case. He stated to me that he could have somebody come get him. At the time, he had no way to, nowhere to go. Now he has a place to go. His mom is going to come get him, and he's indicated that she can come get him.
Your Honor, state would offer on behalf of the city, it's a city case, a withhold credit for time served, $10 filing fee and court costs. I think in their
If he
220.
wants to resolve it, obviously it's up to him, but the court would go along with that offer of time served.
Yeah, I do. I need to. I need to. I want this to be done. I want this to be done permanently.
Understood. All right. We'll be able to take care of it today if that's your choice.
I need to. Sir, I want everything done so I can go about my life, so I can start making right decisions. I mean, I can be honest, I haven't been making right decisions for a long time. I just lost my dad 3 weeks ago. I have been through hell, and I'm still standing as one, but I need to resolve this. Wherever it goes, it goes. I can't be mad at this situation because I put myself there. At the same time, I want to resolve it.
All right.
And I please do that.
This is not the most serious offense that I've ever seen, so I think we'll be able to resolve this today and get you out, and then you can hopefully make a fresh start.
Thank you.
So it's a withhold of adjudication, cost $10 filing fee and credit for time served. When you get out today,
Okay.
you're waiving your right to a trial. You understand that, right?
Yes, ma'am.
No contest. You're not under the influence of any alcohol, drugs, medication, or narcotics.
Nope.
Right? You don't have any mental disability that would affect your decision. Right?
Going slow.
No.
You are a U.S. citizen, right?
Who's private counsel?
Never posted sexually violent.
Never.
Go ahead and take this and sign right there.
This is good. This is good.
Okay. Thanks. Mr. Stiles, in just a minute, I'm going to get a piece of paper that says you wish to resolve your case of camping by pleading no contest. Is that what you wish to do?
Yes.
Do you understand you have a right to have a jury trial as to that case? And at the jury trial, the city prosecutor would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of the offenses that you were charged with.
Yes.
At that trial, you'd have an attorney with you. They'd be talking to the witnesses, examining the evidence against you. Could have presented your own witnesses and your own evidence. your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have spoke at your trial, or you could have remained silent and not spoke. That would have been your decision after you talked that over with your attorney. You would have had a right to have that trial recorded and appeal any error that occurred in the process. You understand you're giving up all your trial rights? Because if I accept this resolution, I'm going to go along with this recommended sentence, which will be a withhold. You'll be sentenced to the time that you've already served. You're going to pay a $10 filing fee plus some court costs, and I'll give you a bunch of time to pay that off, and we will not be having a trial in this matter. Do you understand that?
Yes, sir.
Anyone forcing you or pressuring you into making this decision?
No, so what's going on?
What's going on? You told me that you wanted to resolve your camping ticket by entering a plea. And I'm telling you that you're giving up some rights when you enter a plea, and that would be a right to have the state prove that you did something wrong to a jury.
So do I have a hold? Or
No, I'm not talking about a hold. I'm just talking about the rights you would have if you wanted to go to trial.
okay. Yeah, I understand.
Is anyone, and then I asked you, did anyone force you or pressure you into making this decision?
No, sir.
Anybody make any promises other than what we talked about?
No, sir.
You under the influence of any alcohol or drugs right now?
No, sir.
You have any mental issues or take any medications that are causing you difficulty understanding me?
No, sir.
No?
No, sir.
All right. Court's going to find your responses to me are appropriate, that you are alert and intelligent. You've had an opportunity to think about this decision and briefly discuss it with one of our attorneys. Court's going to accept your plea of no contest to camping. Court's going to withhold adjudication. You're sentenced to a $10 filing fee plus court costs. I think that's going to be $233. I'm not going to assess the public defender's office. Ms. Lampier is acting on as a friend of the court. That'll save you some money. You have 30 days from today's date to appeal this judgment and sentence. If you wish to do so, you must do it in writing. Can't afford an attorney, one will be appointed for you. How much time served does Mr. Styles have?
4 days.
And we'll give you credit for the 4 days that you spent with us. Good luck on your you should be released as to this case today. Good luck on your fresh start, Mr. Styles.
Thank you, sir.
Yes, sir. Mr. Styles, you need to pay that money back within 24 months. That's 2 years, okay?
Yes, sir.
Alonzo Tremaine Burns. Mr. Burns?
Senior.
Good morning, sir.
Good morning.
Sir, you were here based on an allegation of attempted second-degree murder. I do find probable cause has already been found. Let me take a quick look. I think this was a reset. It's been found by way of warrant. Judge Chu has already found probable cause, issued no bond. You're going to stay on no bond until you can get in front of your trial judge. You're also out on bond on another case. That one's on 2022 CF 8903. Court has probable cause. Well, do I have probable cause? Was this allegation subsequent to him being released on bond, Ms. Kennedy Swanson? It looks like it. The date of the offense, September 5th, 2022. He's released on bond on August 4th, 2022. The court finds probable cause to believe committed a new felony offense while you're out on bond. Bond is revoked and set at none in 2022, CF 8903. I'll appoint the Office of the Public Defender on both of those cases. Thanks.
Bonnie should have had one.
How about the new case? I don't have the affidavit on the new case state, so I don't know.
It isn't sure that it's DV. Like, I think the court can just order a no contact. I don't think he needs a no contact order.
Yeah, no contact to the listed victim. Thanks, Mr. Burns. Thank you, officer. State of Florida versus Johnny Ray Williams. Mr. Williams, good Afternoon. Mr. Williams, you are here based on an allegation of possession of methamphetamine. I do find probable cause. Your bond is set in the amount of $1,000, and I'll appoint the office of the public defender. Thanks. State of Florida versus Carlos Aguera Rivera. Good morning, counsel. Thanks for your patience.
Rachel Shaw for Carlos Aguera Rivera.
Sir Aguera, you are here based on an allegation of domestic violence, false imprisonment, and domestic violence battery. I have taken a look at the affidavit. I do find probable cause for those allegations. Court's going to set bond in count 1 in the amount of $1,000 and count 2 in the amount of $1,000. Anyone here? Seeing no witness participation at this point, the court is going to impose no contact with Christina Aguera, and you will not be allowed to return to the Timber River Circle address. Ms. Shaw, do you want to ask your client whether they cohabitate and whether he needs to return one time with law enforcement?
Yes, Your Honor. We're also asking for separate residences, but not the no return. If I can just ask some questions for my client regarding that.
Of course.
State has no objection to the separate residence. I don't believe the victim lives there.
Oh,
I
okay.
believe the victim lives somewhere else, and so just separate residences, Your Honor.
Got it.
If the court's willing to grant that without testimony, that's fine.
Yeah, based on that representation, then the court is going to delete the no return provision and require that they maintain separate residences. What that means is if Ms. Aguera is at the Timber River Circle address, you can't be there. If she's not, then I don't have a problem with you returning. All right. Thank you. Anything further, counsel?
That's all, Your Honor.
Ms. Kendi Swanson?
I'm sorry, I didn't catch the bond amount, Your Honor.
Bond amounts $1,000 as to both counts.
Thank you.
Just call me.
State of Florida versus Elias Southall or Southall. Good afternoon, ma'am. Pronounce your name for me.
Elias Southall.
I didn't get either one right. Ms. Southall, you are here based on allegations of aggravated assault, domestic violence related, and criminal mischief. Court finds probable cause for the allegations. Bond in count 1 is going to be set in the amount of $2,500. Bond in count 2 is going to be set in the amount of $1,000. As a condition of that bond, you're not to have any contact with Daniel Cyrus, and you won't be able to return to the Atrium Circle address. I'll appoint the Office of the Public Defender. Ms. Lanfear, do you want to ask?
Your
I'm sorry,
Honor,
Ms.
Rachel
Shaw?
Shaw for Miss Southall.
All right, thanks. Were these cases related?
No, Your Honor.
All right, the court will allow you to return one time with law enforcement if you need to, if there's any personal property over there.
And Your Honor, we're asking the court to allow third-party contact in regards to their shared child, the 9-month-old.
State has no objection, Your Honor.
You have a family member that can be a go-between for the time being?
My mom.
Your mom? All right. Court will allow the defendant's mother to have contact with Mr. Cyrus to arrange child visitation and the child swap.
Thank you, Your Honor.
Thank you.
Have a good day.
State of Florida versus Anel, Emil. Good afternoon, sir. Did I get your last name correct? Is it Emil? Emil. Sir, you're here based on an allegation of aggravated battery on a pregnant person.
I bought my house and here they put
Don't
me
say
on,
anything.
they put me in default since 2014. They never give me the paper for me to get.
I'm having a tough time hearing you, and I think I will appoint the Office of the Public.
The first time I come here for the house.
Okay,
And here they put me, they put me in default since 2014. They never give me any paper to give me the permission to own the house. And I'm not people's man. I don't want people to live in the house. Like,
Okay.
and here they say if you're from an other country, you should not be living in the United States. There is no maid here. Man. And I'm sick. I cannot stay in that cold. I'm allergic to cold.
All right, so here's what you've been charged with. I will appoint the Office of the Public Defender to represent your interests. The allegation is aggravated battery upon a pregnant person. That person is named Rosalia Horace. Rosalia indicates that she was 5 months pregnant at the time. The allegations in the charging affidavit allege, and I don't know whether the state will be able to prove this or not, but the allegations indicate that this is your cousin, and you hit her with a chair, and when fire rescue showed up, she was, hold on just a sec, I don't want you to talk about the facts of the case. I'm just telling you what's in the charging affidavit. You may disagree with what's in here, and I understand that. That's a discussion between you and your attorney. They observed her bleeding when fire rescue came on scene. That's what the allegations are. I do find probable cause for those allegations. We'll set a bond in your case in the amount of $7,500 with the condition that you have no contact with Rosalia Horace. Ms. Lanfear, do you want to ask Mr. Emil what the living arrangement is?
Your Honor, he indicated that he owns the house. He's the one living there. She's temporarily here from the Bahamas, and that she went to the hospital, and then he's not aware if she's still staying there, but he does not believe so.
Yeah, I don't want people.
There's no objection to just maintaining separate residence. Obviously, if she's there, he can't be there, but if she's not, he can return there.
All right. Court's going to order that you maintain separate residences with Rosalia Horace. What that means, Mr. Emil, is if she is still in the house, and it sounded like she at one point had permission to be there, you're not going to be able to go back to the house. She's not there.
I got my own room and she's at the hospital. The hospital got to give her, the hotel was. I don't have a hotel for her to live. When I go to Haiti, I went hotel room, but when I got my place, I don't want people to tell me what to do with it.
Okay. I'm going to allow you to return one time with law enforcement to get some personal property, and if she's gone, I don't have a problem with you staying. If she's there, you won't be able to be there. You have no contact with her, and you may not maintain separate residences.
It's fine.
That's as much as information as I can give you. I understand you disagree with what's in the charging affidavit, but that's going to conclude today's hearing. State of Florida versus Virginia, Owens. Ms. Owens, good afternoon. Ms. Owens, you were arrested based on an allegation of battery, domestic violence, and battery upon a pregnant person. That was probable cause was previously found by Judge Sanders Morency by way of warrant. Court is going to appoint the Office of the Public Defender to represent your interests. See, you have a limited prior criminal history. The court's going to set bonds in count 1 in the amount of $1,000 and count 2 in the amount of $1,000. Court's going to order that you have no contact with the alleged victim at this time. And that would be Miss. It's Everett. Sorry, Miss Smith. Looks like the alleged victim is Mariah Smith. So no contact with Ms. Smith. The Office of the Public Defender is appointed. Ms. Lamfair, you want to ask about the living arrangements?
Yes, Your Honor.
Thanks. Thank you. See ya.
Yes, Your Honor. She does not live at the residence where this occurred, and they do have separate residences.
Okay. Court's going to require that they maintain separate residences, and ma'am, you will not be allowed to possess any weapons or firearms as a condition of your bond. Thank you.
Okay. You're all set.
State of Florida versus Darius Pugh. Mr. Pugh, good afternoon.
Good afternoon.
You're here based on allegations of aggravated assault on a person over 65 years of age with a deadly weapon and battery on a person 65 years of age or older. We do have a witness present. Good afternoon, sir. If you'll please follow the clerk's instructions.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
My name is Willis C. Robinson. I live at 5103 Keith Place temporarily.
Sir, I'm having a very, very difficult time hearing you, and I know you're very tall and that microphone's very short, but if you could please speak into the microphone, that will greatly assist me.
My name is Willis C. Robinson. I reside at 5103 Keith Place, Orlando.
Thank you, Mr. Robinson. And let me take a quick look. You are one of the listed victims in the case. I do find probable cause for the allegations in which Mr. Pugh is charged. I'm going to be making some determinations about conditions of bond and whether contact is appropriate in this case. Do you want to give me some information regarding those decisions?
Yes, sir. I live there, he lived there also, but I live outside of the house that he lives.
Yes, sir.
So it's two buildings on the property where I live outside.
Okay.
I live in the main house where he was living. And he got a problem, Your Honor. He needed to see a he got a psychological problem. He pointed a gun straight at me, aimed it straight at me, and shot it. And there was neighbors in the neighborhood. He obviously have a problem, a drug problem. And I have neighbors to complain about he's smoking pot. They're sitting in the truck in the driveway.
Yes, sir.
He needs some help.
Are you related to Mr. Pugh in any way?
I raised Mr. Pugh.
Understood.
And I do have a son by his mother, and we've been together about maybe 42 years.
Understood. Right, thank you.
For the court's information, Your Honor, this is not the first incident between this victim and this defendant. The victim has been uncooperative in the past. And so although the defendant has been arrested, we've never filed an information on this case. So the state would ask for a higher bond and no contact, no weapons, no firearms, no drugs, no alcohol.
Is Christine Pugh, is that mom?
Yes.
Thank you. Ms. Lanfear, any questions of our witness?
Yes, Your Honor. Mr. Robinson, good morning. Are you in fear of Mr. Pugh?
No, I'm not really in fear. I was in fear yesterday when he pulled that gun, when he pointed that gun at me, and when he pulled the trigger. It was a black revolver. I'm looking at the bullets, and he hit me in my chest holding the gun in one hand and hitting me in my chest in the other hand. So I don't know what that was. He never done it before. He never pulled a gun on me before. So I don't know if he got a drug problem. What's his problem is? But man, his mother been together about 32 years.
And you indicated earlier that you have separate residences,
Yes.
possibly on the same property, but they're different buildings?
Yes.
Um,
He lived in the main house. We built a $13,000 barn in the backyard, and that's where I live.
Mhm.
I was currently living at 2868 North Powers Drive, which is my son by Christine Pugh. That's my biological son.
Mhm.
He's my stepson. I stepped up to the plate when his daddy didn't, but his dad is dead now. God bless his soul. But I raised him. But I didn't raise him, to carry a gun. I mean, I'm concerned about him.
And if he's released on these charges, do you feel comfortable with him going back to the residence he was living at? No?
No, not right now. No,
Okay.
I'd rather, if I have to, if I can judge give me enough time to leave. But I don't have nowhere to go right now because I was living in my son's condo, and his mother offered me into the big house, but I refused because of him. So I decided to live into the barn. That's where I currently stay right now, but on the same property.
Okay. No further questions, Your Honor.
Thank you. Ms. Kennedy Swanson, any questions?
I have no questions, Your Honor, just argument.
All right. Thank you. Mr. Robinson, thank you for your testimony, sir.
Yes, sir. Thank you.
Either side?
Your Honor, I would just ask the court to not allow him to return to the residence. I understand that the victim said he lives on some part of the property. I just think because this is a firearm that is being used, that obviously bullets travel farther than further distance. So we would ask that he not be allowed to return to the address. Also that he, no weapons and no firearms. And Your Honor, I understand what you heard, that he shot a gun at the victim, even though there were no bullets, I guess, in it at that time. I think that just shows the dangerous nature of the situation.
The affidavit indicates a gunshot went off and a bullet hole was located in the roof trim. Mr. Pugh, I do find probable cause, as I previously announced. Court's going to set bond, count one in the amount of $10,000 and count two in the amount of $5,000. You're not going to be allowed to return to the Keith Place address. Allow you to return one time with some with law enforcement to get some personal property while this case gets sorted out. And you're to have no contact with your stepdad, Mr. Robinson. Thank you.
And then you can take this with you. With the bondsman?
Throw that at you.
It's 1,500.
State of Florida versus Stephen Rosado. Mr. Rosado, good afternoon.
Good afternoon.
Mr. Rosado, the allegations are that you're here on are aggravated battery with great bodily harm, tampering with a witness to hinder communication, and battery domestic violence. Read the charging affidavit. There is probable cause for those allegations. I'll appoint the Office of the Public Defender to represent you. Bond in count one is going to be set in the amount of $5,000. It's count two in the amount of $2,500. It's count three in the amount of $1,000. With the special condition that you have no contact whatsoever with the alleged victim in this case. Do not make this easy. That's going to be Teresa Jacqueline Kelly. You're not going to be able to return to the hometown suites on Delegates Drive. I'll allow you to return one time with law enforcement if you have some personal property there. Fortunately, you're out on bond already on 2022 CF 10014. That's a felony allegation. Court's got probable cause to believe you committed a new felony offense while you're out on felony bond. The bond's going to be revoked in that case and currently set it in the amount of none. I'll issue or I'll appoint the Office of the Public Defender on that case as well. Thanks. State of Florida versus Reuben Serrano Osorio, excuse me.
Good morning or afternoon.
Good afternoon, yeah. Good afternoon, Mr. Serrano. Mr. Serrano, you are here with us based on an allegation of false imprisonment, domestic violence related, harassing a witness, tampering with a witness, domestic violence related, and battery, domestic violence related. Taking a look at the charging affidavit, I do find probable cause for your arrest. Court's going to,
I think he qualifies for pretrial release, Your Honor.
let me take a quick look. State there were allegations of prior domestic violence that were not prosecuted.
And have one moment, Your Honor.
Sure.
Just see his two last names, so it's going to take a extra second
Got it.
on how we have listed. I'm not seeing our system, I'm just seeing, I'm gonna guess it's because of the spelling of his last name.
Right. Officer, it looks like there were Florida arrests listed on the review for pretrial release.
Yes, he does qualify for pretrial.
Based on the risk assessment results being low, the court will approve pretrial release with the following conditions. You're not to have any contact whatsoever with the listed victim. Not going to be able to go back to the ale house. I think that's where this occurred.
That's fine.
Sorry, give me just a sec. Court will require that you maintain separate residences if you reside together. Thank you.
Thank you. I'm done. Thank you.
State of Florida versus Icurious Smith. Ms. Smith, good afternoon. Good afternoon, sir.
Good afternoon, sir.
Sir, we're going to place you under oath if you'll follow the instructions of the Madam Clerk.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
My name is Travis Pierre.
Mr. Pierre, you are listed as the victim in the charging affidavit. I'm going to be making some determinations as to conditions of bond if the court finds probable cause. And you may give me some information to make those considerations. Do you wish to give me some information?
Yes, sir.
All right. Thanks. Have any issues like this ever occurred before?
No, sir.
No? Are you in fear of Ms. Smith?
No, sir.
Do you have a means of communication in case you became in fear of further acts?
No, sir.
Do you guys live together at the Beacon Hill address?
No, sir.
All right. Would you prefer that she not be permitted to return to that location?
Yes, sir.
Do you wish to have contact with Ms. Smith?
Yes, sir.
No, sir?
Yes, sir.
Yes, you do? All right. Any follow-up questions, Ms. Lampier?
No, Your Honor.
Ms. Kendi Swanson?
I just have a question for PTR. I see that he didn't she didn't qualify. Is that only because you couldn't contact the
No,
victim?
per admin order, he didn't she didn't qualify.
Okay, thank you. That was the only question, Your Honor.
Got it. All right. Thank you, sir, for that information.
No problem, sir.
And Your Honor, may I be heard as to probable cause as to count one?
Yes.
Thank you, Your Honor. So I read in the affidavit, it says that Ms. Smith said she thought to herself that she wanted to hurt him with the glass bottle, that she throws it on the ground. He doesn't even appear to be awake at this point, so I don't believe that there is enough to say that this was an aggravated assault. Her simply throwing a bottle on the ground doesn't mean she was throwing it at him or intended to cause him any distress.
Ms. Kendi Swanson?
That's fine, Your Honor. We can find PC for just a battery.
Yeah, I noted, I have a big note that it appeared that the victim was asleep, so therefore could not have been in fear of something he was not aware of until the glass shattered. So the court is going to find no PC as to count one, ROR her as to the allegation of aggravated assault. Ms. Smith, the state still may file charges on that, but this is only as to the considerations of bond. If they decide to do that, you'll be noticed. I do find probable cause for the allegation of battery domestic violence. Will set bond in the amount.
That would change the qualification of PTR based on the no PC of the aggravated assault.
Oh.
She may qualify.
Your Honor wants to do bond, and then if she so qualifies.
If you qualify for pretrial release, I'll release you on pretrial release based on the finding of no PC as to count one. Otherwise, it's going to be a $1,000 bond with the condition that you have no hostile contact with the alleged victim. However, you're not to return to his property, and that's the Beacon Hill Loop address. Thank you.
Thank you.
State of Florida versus Antonio Vasquez. Sir, good afternoon. You're here based on an allegation of aggravated battery upon a pregnant person. I see that we do have a witness present. Ma'am, good afternoon. Please follow the clerk's instructions.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Amanda Vasquez.
Ms. Vasquez, you are listed as the alleged victim in the charging affidavit against Mr. Vasquez. As you have seen, I'm going to make some decisions regarding contact and return to a shared residence. Do you wish to give me some information about that?
I think we maybe need
I'm having a tough time hearing you. I'm sorry.
I think we need time apart, but I don't have a problem living with him.
All right, thank you. And this is your brother, right?
Yes, sir.
Do you all live in the same house?
Yes.
Do you have family here in town?
Yes.
Additional family?
Yes.
Do you wish to have contact with your brother while this is getting sorted out?
I don't see why not, if he's okay with it.
Okay. Well, it's up to you. You're listed as the victim, so I can order no contact, which is the most protection I'm able to give you pursuant to court order. The second layer under that would be no hostile contact, which would mean that he wouldn't be able to put his hands on you. He wouldn't be able to have a verbal argument with you, swear at you, anything like that.
That sounds good.
All right, thank you. Anybody home with you at the Benson Park Boulevard address? Who lives there?
My mom and my mom's boyfriend, and then him and I.
Mom and mom's boyfriend?
Yeah.
Okay. Right, thanks. I think I had gotten some information that Mom was going to give me some information regarding Mr. Vasquez. Is Mom here as well, or is it?
He is.
She is? Okay. Slamfir, any questions of our witness?
Miss Vasquez, are you afraid of your brother?
No, ma'am.
Okay. And if he's released, do you want him to live in the same residence as you?
Yes, because he wants to be there for my son.
Okay. No further questions, Your Honor.
Ms. Kennedy Swanson, any questions for Ms. Vasquez?
Has anything that's happened in the past?
So he's autistic, so he does usually have temper tantrums, but nothing this bad. He's been really good. It was just, suddenly.
No further questions.
Thank you. Thank you for that information, Ms. Vasquez. Let's talk to Mom if you wish to give me some information. Ma'am, if you'll please raise your right hand and follow the instructions of the court.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth? Please state your name for the record.
Mary Ellis Vasquez.
Thank you, Ms. Vasquez. So your daughter and son live at the house, is that correct?
Correct.
All right. What information would you like for me to have about Antonio?
I just know that he's been really good for a good amount of time. He's just had a lot of stressors lately, and he doesn't handle that very well.
Understood.
But he is undergoing treatment with a psychiatrist, and he had fallen off from the therapy, which I think that helped him a lot with the stressors in his life. And if we could just start that back up, that I think he'd be just fine.
If the court ordered that as any condition of release, would that be helpful for the family?
That would. We have insurance. It's not a problem. Yeah.
All right, thank you. Ms. Lampier, any questions?
No, Your Honor.
Ms. Kennedy Swanson, anything further?
No, Your Honor.
All right, has there been issues of violence in the past in the house?
However, he, again, like she said, temper tantrums with autism related. I've always been able to control him. And now with my boyfriend living with me, he talks him. He's very good with him, talking him down and calming him down. But it's never been this. It's never gotten physical like this before. No,
Understand.
Not with me either.
State, I don't see any prior criminal history.
I don't see any either, Your Honor.
All right, thank you. Thank you for that information, ma'am. Let me ask PTR, what is the hesitation medical? Is that?
No, he doesn't qualify for our admin order.
Is the charge itself?
Yes.
Slamfair, do you wish to be? I'm sorry, ma'am.
Sorry, I forgot to say something. I wanted to drop the charges that I pressed, if that's okay.
Okay.
Possible.
So a lot of people think the judge can just make that decision. That's a decision from the state of Florida. The prosecutors make that decision. There's a process that you can go through and fill out some paperwork that lets them know what your preference is. They will take your preference into consideration, but ultimately the decision is going to be theirs. But your statement here on the record is noted, and Madam Assistant State Attorney is probably making some notes. So.
Okay.
So thank you for that statement.
Yeah, thank you, sir.
Yes, ma'am. All right, as to the issue of bond, Ms. Lampier?
Yes, Your Honor, considering all the testimony today, I would ask for ROR. He doesn't qualify for pretrial release. I imagine that his family is going to be the one to pay the bond and take him to court dates if there are any court dates. And I feel as though they've kind of nailed it on the head, saying this was an incident that they don't anticipate will happen again. And seems like just a bad situation for everyone involved.
Ms. Kennedy Swanson?
I'm gonna object to an ROR, but I have no issue with a very low bond, Your Honor. And I would also ask that we order PTR only for it so that he attends doctor's evaluation and any treatment, if the court so inclined.
Officer, if the court orders PTR, will PTR take him?
If he doesn't qualify, it can be like one of the conditions if you wanted to list.
Yeah. I'm going to set a $150 bond in this case. And Mr. Vasquez, I know there's been a lot of talk about you, and I understand that you're standing right here trying to make some decisions. It's always a good idea for somebody who's accused of a crime not to talk to the judge, so I'm not ignoring you. But I did want to get that information from your family. I'm going to set a bond in the amount of $150. And with the special condition of your bond that you resume with your treatment, and that will be as a condition of your bond, that you abide by the rules of the house and that you not have any hostile contact with your family members and the listed victim. Do you understand all that?
I understand.
All right. Thank you. As soon as your family posts the bond, you'll be released. Please go back to your meetings and do your best to be kind to your family members. Good luck. And for the family members, he should be bondable, and you'll be able to have that discussion with the folks downstairs. Thank you. State of Florida versus Brandon Verola. Mr. Verola, good afternoon. Mr. Verola, you were here on an allegation of child abuse. I have read the charging affidavit. I do find taking all the things in the charging affidavit is true, which I must at this point. That there's probable cause for that allegation. Your bond is going to be set in the amount of $2,500. It does not appear that you qualify for the services of the Public Defender's Office, as you make in excess of what the court can consider as indigent. So if you wish to be represented by counsel, you need to talk to one of our local attorneys. And at this point, the court is going to impose conditions of no contact with the alleged victim in this case, which is Wyatt Johnson, who is a minor. And for the time being, until this gets sorted out, you're not going to be able to go back to the, well, I'm going to require separate residences between you and Wyatt Johnson. If that is your home, I will allow you to return one time with law enforcement to get some personal property while this case gets sorted out. Thank you. State of Florida versus Juan Acevedo. Mr. Acevedo, good afternoon. Good afternoon, sir.
Good afternoon.
Mr. Acevedo, you are here on 3 allegations. 1 allegation is disorderly conduct, the next is resisting an officer without violence, and the third is battery, domestic violence for something alleged to have happened in the, looks like the 7-Eleven. I understand the victim is your brother, is that correct? Sir, if you'll please follow the instructions of Madam Clerk.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
I swear.
Please state your name for the record.
Jensen Rodriguez.
Mr. Rodriguez, thanks for joining us. You can probably anticipate our questions that I'll ask you because you've seen me go through this discussion a couple times. I will be making determinations if I find probable cause for the criminal allegation as to contact and any residential considerations if you guys cohabitate. Do you wish to give me some information about that?
Yes, sir.
All right, whenever you're ready.
You want to ask the questions or you?
Sure, I'll ask you some questions. This is your brother, correct?
That is correct.
Any acts of violence in the past?
None at all.
All right, thanks. Do you have any fear of having contact with your brother?
None at all.
Do you guys live in the same place?
We do not. He actually works on the road Monday through Friday. I'm always with him when he's not working. So he's usually home just on the weekends.
Okay.
When he is here on the weekends, he's usually always with me. Again, he is my younger brother. I take care of him, whenever, wherever, and there is no fear in me of him because that is my younger brother, and I've always taken care of that kid.
Understood. Do you have a means of communication if you become fearful of some issue of violence, like a phone? Do you have a phone?
Yeah,
absolutely. All right, thanks. So does he stay with you on the weekends?
Yeah, he usually, he usually stays with me. He'll visit my mom because my mom lives like about 5 minutes from my house.
Okay.
But yeah, he's usually always with me.
All right, thank you. Anyone in your household, any concerns for their safety?
None at all, none at all.
All right, thank you. Ms. Lanfair, any questions for our witness?
No, Your Honor.
Ms. Kenny Swanson?
No, Your Honor.
All right, thank you. Thank you for that information, sir.
Thank you.
Sir, I do find probable cause for your initial arrest, and we'll be setting bonds. As to the disorderly conduct, your bond is set in the amount of
Your
200.
Honor, I think he qualifies.
Yes, he qualifies for pretrial.
No objection, Your Honor.
Let me take a quick look. State, was drugs or alcohol alleged to be involved in this issue?
I believe alcohol, Your Honor.
All right. So the court's going to release you on straight pretrial release with the special condition that you, number one, have no hostile contact with your brother. That means exactly what it sounds like. No fights, no getting into his face, no threatening text, tweets, or messages electronically. I'm also going to order that you consume no alcohol as a condition of your pretrial release because it seems that was a contributing factor. And I'll appoint the Office of the Public Defender to represent you. Thank you.
Take that, take that.
Take care.
Mr. Boyle?
Yes, sir.
Good afternoon, Mr. Boyle.
How are you?
I'm well, thanks for asking. Mr. Boyle, you are here based on an allegation of battery, domestic violence related. I have taken a look at the charging affidavit and taking the facts in the charging affidavit as true, which at this point I do find probable cause for your initial arrest. I see that you've got no prior criminal history. I'm going to release you on pretrial release. I've got no information regarding the alleged victim in this case, or no input from them. So at this point, I am going to order no contact between you and the alleged victim, Linda Boyle, I understand is your wife. I'm also going to rule that you may not return to the Park Ridge Street address till this gets sorted out. I will allow you to return one time to get some personal belongings as this case is pending. Thank you, sir.
With all due respect, my wife and I work together. So
Pardon me?
How is this no contact thing going to work?
They work together, Your Honor.
We work together.
Okay.
Out of the home or?
Where do you work?
Land Investment Services,
Okay.
architectural engineering firm in Oviedo.
All right, thank you.
I'm sorry, do they work, is it a home business or is there like a location of the business?
It's a end cap business in an office building.
Okay, so you've got a physical brick and mortar
Yes.
building?
Yes.
All right, thank you. And you and your wife both go to the same building
Yes.
during the week?
Yes. We
All right.
ride back and forth together.
Any other employees present?
Yes.
Okay,
We have another one in the downstairs, and then there's probably 10 or 11 more on the second floor between two other suites.
okay.
I have no problem as long as they're at the physical brick and mortar location having as little contact as possible, but no, we're
Okay.
maintain separate residences.
Court's going to allow incidental contact for employment purposes only at this point. You can, I've appointed, does he qualify? He doesn't qualify for this.
Yes, he does qualify.
He qualifies for pretrial release, but not for the,
PD.
yeah. You make far in excess of what the court can consider to be indigent for purposes of appointment of the Office of the Public Defender. So I'm not going to appoint the Office of the Public Defender. If you wish to be represented by an attorney, you can talk to one of our local attorneys. The state's going to be taking this charging affidavit and making a decision as to whether they're going to be moving forward with any prosecution. They're the ones that bring criminal charges against anybody, not the court. So you've been accused of a crime, but at this point you are presumed to be innocent. I will, because I don't have a lot of information about your situation with your wife and input from her, I'm going to order no contact, with the exception that you may have incidental contact at the employment facility, at your shop, and that if there's incidental contact that needs to happen to keep the business running, and the court will allow that to happen. Outside of that environment, no contact for right now. Your attorney can bring you back before a trial court if the charges are imposed, and we can revisit that decision.
Okay, can I have her pick me up today?
Negative. Nope. Nope. So that's going to be anything outside of the work environment, no contact. So you're going to have a friend or a family member pick you up once you are released on pretrial release. And I'll allow you to return to that house one time with law enforcement to get some personal property until this case gets sorted out.
Okay.
All right? You understand?
Kinda, but not really.
I understand. I know you're not happy with the situation, but that
I've never been in trouble before in my life, and I'm scared to death.
I understand.
We
So
were just horsing around, and it got a little out of control. It didn't hurt her on purpose. And I didn't.
understood. So let me advise you of this. I don't want you to say anything to me that the state could use to prosecute you with. So why don't you share that discussion with your attorney? You're going to be released today, and the conditions of your release will be explained to you. I don't know whether the state's going to end up prosecuting you on this case or not. That'll be up to them. All right. Yes, sir.
Write something in my behalf saying that we were just horsing around.
That's possible. Good luck to you, sir. Return one time with law enforcement. No return.
Yep, all that's yours. Okay.
State of Florida versus Todeja Gregory. Did I get close on your name?
Yes, you got it correct.
Ms. Gregory, you are here based on an allegation of battery, domestic violence related. I don't see any prior criminal history. The court's going to release you on pretrial release. I do find probable cause for the initial allegations. I will appoint the Office of the Public Defender to represent you.
Your Honor.
Yes.
Ms. Gregory just requested a bond instead of pretrial release.
There's no difference to a $500 bond, Your Honor.
Sure. If you want straight cash bond, I'll set bond in the amount of $500 or pretrial release with the special conditions that you not have any contact with Kevin Kennedy, and you're not going to be allowed to go back to the Bent Pine Drive address. Ms. Lanfear, do you want to inquire?
There's one thing she indicated to me, Your Honor. She's from out of county. You said Broward.
I live in Orlando, but I was going to pick up if I was
Okay. Yes, so she needs to go back to Broward County. I'm not sure if pretrial release would allow her to go back there.
That's going to be her home address. Will pretrial release supervise somebody out of another county?
Yes, she could do pretrial with the, from a different county, but she stated she lives here in Orlando.
She's going to move back to Broward. She currently lives in Orlando, but will move back to Broward County.
Okay.
Okay. All right, that's between you and pretrial release. Either it's PTR or cash bond, but you're not allowed to have contact with Kevin, and you can't go back to that apartment. Do you understand? All right, thank you.
How much was the bond, Your Honor? I'm sorry.
500 or PTR.
You have to talk to the bond firm about that one, but I think you should be able to pay for it. So, no contact with Kevin until this is sorted out. So, thank you, Your Honor.
Thank you. State of Florida versus Brian Hills. Doesn't look like Brian Hills, so.
Yeah, we have Nero Groening, Your Honor.
I'm sorry, I can't hear you, officer.
Groening.
Thanks. Ronan? Groening, got it. Are you near a Groening?
Yes, sir.
Thank you. Ms. Groening, you are here with us based on an allegation of battery domestic violence. I see that we have a witness that is present. Good afternoon, sir.
Good afternoon, sir.
Sir, we are going to place you under oath. If you'll please follow the instructions of Madam Clerk.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Sir, good afternoon. You've seen me go through this process before. I'm going to be making a determination as to whether there's probable cause for Ms. Groening's initial arrest. Then I'll be considering conditions of bond, which will include whether it's appropriate to have contact with Ms. Groening and whether you wish, if you cohabitate, whether you wish her to return to the family home. Do you wish to give me some information about that?
Yes, sir. I want to make it clear to the court.
I'm having a tough time hearing you, so if you'll speak up.
Yes, sir. I wanted to make it clear to the court I wouldn't be pursuing any charges. My kids and I are actually very worried about her and want her to return home.
Understood. Thank you. All right, as I previously explained, I don't have the ability to bring or drop charges at this point. That's entirely up to the state of Florida. There's a process that you can follow through their office that will at least formalize your wishes and give them some input in what they'd like to do with the criminal allegations. So I am guessing from your testimony that because you wish for her to return back to the family home, you do not have any fear of Ms. Groening. Is that correct?
No, sir.
Are there any minor children in the home?
Yes, sir.
All right. How old are the children?
Daughter's 14. My son is 7.
Any concerns of any concerns to their safety?
No, sir.
Do you have a means of communication in the home, such as a cell phone or a house phone?
Yes.
Thank you. Just a moment. Ms. Fair, any questions?
No, Your Honor.
Ms. Kennedy Swanson?
No, Your Honor.
Sir, thank you for that information. Ms. Groening, I do find probable cause for your initial arrest. You do qualify for pretrial release. I am going to release you on pretrial release with the following conditions. You're to have no hostile contact with Mr. Groening. Court will allow you to return to the family home. Apparently this happened in front of the children. You guys have to sort this out. It's alleged that the children observed this. Is that correct, Mr. Groening?
No, that is not correct, sir. The DCF actually did show up afterwards and made it clear that my daughter was locked in her room and my son was on a bed on a cell phone. So, no, this was not in front of the children.
All right. The affidavit indicates that the 7-year-old saw this occur, but since there is a active DCF investigation, I will defer to them. All right, that's going to conclude our initial appearance. Thank you. Mr. Hills? Hello. All right. right, Mr. Hills, you are with us based on an allegation in a new law offense. That allegation is a violation of a pretrial release condition for domestic violence. I have read the charging affidavit. Indicates that you went as directed by law enforcement with to get some personal property, and then it alleges, and I don't want you to comment on this, but what's in the charging affidavit indicates that you went back to continue to load some stuff the next day. I think there is probable cause, at least, to find a violation of the pretrial release condition, as that violates the one-time return. And I will appoint the Office of the Public Defender on that case and set a bond in the amount of $500. You're out on bond on the original case, which is aggravated assault with a deadly weapon and battery domestic violence related. State, do you wish to be heard as to that case?
Yes, Your Honor, the bond should be revoked and be held at no bond, and let the trial judge handle that case.
Thank you. Ms. Lanfear, I believe your office is already appointed.
Yes, Your Honor.
All right, court has probable cause to believe that you committed a new law offense while you were out on bond on the old law offense. I'm going to revoke your bond in that case, or and hold you no bond until you can get in front of your trial judge and let him know your decision process between the new law offense. They may reconsider that. I'll appoint the Office of the Public Defender if they weren't previously appointed. Thank you. All right, thank you. He qualifies, no. He was unable to sign based on him being non-compliant. I would appoint the Office of the Public Defender. Do you wish to have a reset or waive?
Could we reset him, Your Honor?
Mr. Norek will be seen by the IA judge, or the regular IA judge tomorrow. State of Florida versus Crystal Reese.
Hi, Your Honor.
Hi, Ms. Reese.
How are you doing?
I'm well, thank you. Ms. Reese, you are with us based on an allegation of battery domestic violence related.
Yes, sir.
I do find probable cause from what's in the affidavit. You qualify for pretrial release. I will.
Your Honor, she indicated she'd also just like a bond set.
You qualify for pretrial release or a monetary bond. Your bond will be set in the amount of $500.
Yes, sir.
With these special conditions,
Yes.
either pretrial release or your bond, that you're not to have any contact with Jerome Swopeshire, and you can't go back to the Cinder Lane Parkway address. Ms. Lanfear, does she need to get some stuff out of that address?
Yes, Your Honor, she indicated that it's her apartment. Her name is on the lease. He should not be there, so we would ask that they maintain separate residences, and if he is there, she will need to find another place to stay.
Yeah, it says in the affidavit they've been living together as a family unit for a year. I can't kick him out, but the court will modify that to that you maintain separate residences with Mr. Swopeshire. If he is there, that means that you can't be there. But is he taking care of your daughter right now?
Well, my daughter's with my mom, but it's where me and my daughter, you know. I don't know.
I asked. I just so your daughter's good with mom, and we don't know whether he's there or not. So.
Correct.
All right, so maintain separate residences. If he's still there, you're going to have to go through the civil process to get him out, but if that's your apartment. But
Yes, sir.
all right, good luck.
Thank you so much, Judge.
Yes, ma'am.
Okay, thank you.
You're welcome.
State of Florida versus Rashad Thomas. Mr. Thomas, good afternoon. You're here based on an allegation of battery domestic violence. I took a look at the charging affidavit. Do find probable cause, bless you, for your arrest. We'll set bond the amount of $1,000 with the special condition that you not have any contact with Tarika Williams, and you're not going to be able to return to the Palmetto Ridge Circle address. I will allow you to return one time with law enforcement if you have some personal property there. Good luck. Mr. Webb?
Sir.
Good afternoon, Mr. Webb. You're here based on allegations of battery, domestic violence, and tampering, harassing a witness. As to the tampering allegation and the battery, domestic violence, I do find probable cause for your initial arrest. Court will be setting bonds in those amounts, in those cases, in the amount of $1,500 as to count one, $1,000 as to count two. You have no contact with the alleged victim in this case. That's going to be Autumn Nguyen, and you're not going to be able to return to the location where this is alleged to have occurred, which is the Apley Circle address. Court will allow you to return one time with some law enforcement to get any personal property while this case is pending. Yes, sir.
Have they had any contact with when how do I get out of here? That's what I'm trying to figure out, 'cause
State of Florida versus Malcolm Brown. I hate to keep resetting stuff. Ms. Lanfear, the court would be appointing the Office of the Public Defender to represent Mr. Brown's interests. What would you like me to do?
Your Honor.
What's that?
We'll waive his appearance.
Court's going to find probable cause for the allegations of robbery, false imprisonment, and exposure of sexual organs. The court is going to set bonds in the amount of $10,000 is count one, $6,000 is count two, $1,000 is to count three. Thank you. Malcolm Brown. Mr. Bryant? Good afternoon, Mr. Bryant.
Good morning.
I wish it was morning.
Good afternoon.
Mr. Bryant, you're here with us based on a couple cases. One's a new case, and that's an allegation of possession of cocaine with intent to sell or deliver. That was filed by way of a warrant. That warrant was from an incident that was alleged to have occurred on July 1st, 2022. It alleges that possession of cocaine with intent to sell or deliver. Judge Munyon found probable cause and issued the bond in the amount of $10,000. Unfortunately, you are out on bond on two other cases when that is alleged to have occurred. One is sale and delivery of cannabis, and one is possession of cocaine, possession of drug paraphernalia. Those case numbers are 2022 CF 6107 and 2022 CF 6108. Based on there being probable cause to believe that you violated the law while you're out on bond on those cases, the court's going to revoke your bond, and your bond will be set in the amount of none on those cases. I'll appoint the Office of the Public Defender to represent your interests on all three of your cases. Thanks.
Those other two. You gotta wait to get a bond on them.
What they tell them, there's no action been
information for all of you.
Thank you, sir.
Yes, sir. Thank you. State of Florida versus Michael Cooper. Mr. Cooper, good afternoon. You were arrested based on an allegation of possession of methamphetamine, MDMA, or ecstasy. The court finds probable cause for your arrest. Will set bond in the amount of $1,000 and appoint the office of the public defender. Thank you. State of Florida versus Jesse Figueroa. Thank you. State of Florida versus Diego Gomez.
Yes.
Mr. Gomez, good afternoon.
Good afternoon.
Mr. Gomez, you are here with us based on an allegation of trafficking in oxycodone, possession of oxycodone, and possession of cocaine. Court finds probable cause for counts 1 and 3. I'll find probable cause for count 2, but it looks entirely duplicative of count 1. The court's going to stay the bond in count 1 in the amount of $100,000. I'll ROR you as to count 2. Your bond in count 3 is set in the amount of $1,000, and I'll appoint the office of the public defender to represent your interest. Thanks.
And
Jeanette Laponte. Court will
We're gonna
appoint you.
ask that we don't take any action on the out of bond case.
On-
Okay, right? Yep.
Court's going to appoint the office of the public defender to represent Ms. Lapointe's interest. She's medically unable to join us.
We'll waive, Your Honor.
We'll accept a waiver of her appearance. Court finds probable cause for her arrest, sets bond in the amount of $1,000 with the special condition of her bond that she not possess or consume any illegal substances. State she's got 5 felony convictions, 29 misdemeanor convictions, 8 failures to appear, 15 who knows. And the state's asking that the court not take any action on the.
My understanding is in this case, she is in our prostitution diversion, and so it's more than just drugs are related to that.
Understood.
And so that's the reason why for this case.
I suspect she's out on ROR if she's in diversion, so I can't find that she's violated the conditions of her bond, so the court will take no action as to 2021 CF 14687. Thanks for that clarification. State of Florida versus Brian Ligori. State of Florida versus Calvin Lloyd. State will appoint the office of the public defender to represent Mr. Lloyd's interests. He's medically unable to attend.
We'll waive his appearance, Your Honor.
We'll accept a waiver. Court finds probable cause for the allegations of burglary of a structure and possession of drug paraphernalia. Bond will be set in the amount of $3,500 as to count 1, $100 as to count 2. State of Florida versus John Doe.
Should be Stephen Lowry. Yep.
All right. Has Mr. Lowry been identified by anybody? Officer?
I was checking. Yes, he has been identified.
All right, thank you.
His mental health.
Yes, ma'am.
Court will find that our John Doe has been identified as Stephen Michael Lowry. He's charged with 3 counts. Count 1 is false imprisonment, count 2 is battery, count 3 is resisting an officer without violence. David indicates causing a problem at the Hash House Restaurant. Court appoints the Office of the Public Defender. What would you like me to do, Ms. Lamfair?
Your Honor, we'll waive considering the reason as to why he is mental health. We don't know that he'll be back tomorrow.
All right, court finds there's probable cause for the allegations upon count 1, 2, and 3 will be stayed in the amounts of $3,500 and $500. He's not to return to the Hash House Restaurant located at 5350 International Drive and have no contact with the alleged victim in this case, which would be Samantha Voigt. State of Florida versus Robert James Newdigate. Court will appoint the Office of the Public Defender to represent Mr. Newdigate's interests on 2022 CF 11168.
And we'll waive his appearance, Your Honor.
Court finds probable cause of the allegation of possession of a firearm by a convicted felon, sets bond in the amount of $4,000. He's out on bond on a felony offense. That's in 2022 CF 9469. The court finds probable cause to believe he's violated the law while out on bond. Bond in that case is revoked, set in the amount of none. The court will appoint the Office of the Public Defender to represent his interests. State of Florida versus Jordan Robinson. Good afternoon, Mr. Robinson. Mr. Robinson, you are with us based on a couple issues. Number one is in 2022 CF 11185, there's an allegation of fleeing or attempting to elude a police officer. I do find probable cause for that allegation and will set a bond in that case in the amount of $3,500. Unfortunately, you're out on bond already, or I'm sorry, you're on pretrial diversion. Ms. Kendi Swanson, what's the status of that?
It looks like the contract looks like he's pending a contract signing. We approved it on 7/21 in our office and went to DOC for a contract signing.
Okay.
I don't know the date of that. I don't know the facts. I don't know if this is gonna kick him out.
Right, I understand. Are you showing that he was on bond? Did the judge do anything at the time of the contract signing?
I don't know the answer to that, Your Honor. Let me see if I can go to the clerk's site. Something happened on the 12th where they sent something to the bondsman. Let me see. They just set another date. So I can't see what Judge Wilson did with the bond. She held the case in abeyance and set another status date for October the 12th. Nope, she canceled it. I'm sorry, she canceled that. So I don't think it has any status dates now that it's been approved and set for contract signing. Looks like he went to court, I think, August the 10th, and that's when court canceled any future dates.
And it looks like the bond was discharged.
Was it discharged?
Mhm. Yeah, according to the clerk's office, it was discharged, so he's not out on bond.
All right, I'm going to take no action as to the 2021 CF 6160. I'm not sure I have any statutory authority to take any action while the case is in diversion.
I'm sorry, what was the bond amount on the fleeing?
$3,500.
Thank you, Your Honor.
I don't have one with me, but I've got all your contact info on here, so you're good. You can just ask for me. I'm not going to be your attorney.
What's your name?
Kaylee.
State of Florida versus Raymond Selvin. Court will appoint the Office of the Public Defender to represent Mr. Selvin's interests.
We will waive his appearance, Your Honor.
Court will accept a waiver of his appearance, find probable cause For possession of oxycodone, possession of cocaine, possession of drug paraphernalia, bonds will be set in the amount of $1,000, and $500 with the special condition that he not possess or consume any illegal substances. State of Florida versus Richard Thomas. Mr. Thomas, good afternoon. Mr. Thomas, you were here with us based on an allegation, a new allegation of fleeing or attempting to elude a police officer and obstruction of the execution of a search warrant. Let me quick.
I would not advise you to speak right now.
Okay, one sec. I do find probable cause of the fleeing or attempting to elude a police officer. I do not find probable cause of the obstruction of execution of a search warrant. Bond in count one is going to be set in the amount of $3,500. Unfortunately, you're out on bond on a bunch of other stuff. That's in 2021 CF 15748. And you've got a criminal traffic citation of DUI in 2022 CT 4390. I have probable cause to believe you committed a new law offense while you were out on bond on those cases. Your bond's going to be revoked and set at none. I will appoint the Office of the Public Defender on all three cases. Thank you. IROR is to count two. PD is appointed on, State of Florida versus, is it Olson? O'Nelson?
Sir.
Mr. O'Nelson, Fleur. Sir, Fleur, you were here with us based on a warrant. That's a warrant for failing to appear. The underlying offense was petty theft. It alleges that you failed to appear on June 28th. And you do have a bond in this case, and that bond is set in the amount of $500. It says on the affidavit that it's zero. That's incorrect. So you've got a bond. And I'll appoint the Office of the Public Defender if they weren't previously appointed. Good luck. State of Florida versus Lucinda Russell. Court appoints the Office of the Public Defender on Ms. Russell's case if not previously appointed.
And we'll waive.
She failed to appear for sentencing on October 19th, 2021 for an allegation of petty theft of $100 or more. Underlying bond was forfeited. However, the judge in that case issued a bond in the amount of $1,000. State of Florida versus Camboim DeSoto. Court appoints the Office of the Public Defender to represent this gentleman.
Do you think he'll come back tomorrow?
He qualifies for a $500 bond. Do you wish to waive?
We'll waive, Your Honor.
We'll accept the waiver of his appearance. Bond is set in the amount of $500. State of Florida versus Raimundo Carrasquillo Mata. Mr. Carrasquillo.
I need your help.
Let's talk about it, Mr. Carrasquillo. Mr. Carrasquillo, you were arrested based on allegations of driving while license suspended, no motor vehicle registration, and attaching a tag to an unassigned vehicle. I'm gonna appoint the Office of the Public Defender to represent your interests.
May I be heard as to count 3?
Sure.
So as to attaching tag not assigned on a vehicle, there is case law, it's Phillips versus State, that says that in order for somebody to have this allegation against them, the officer must see or have an admission as to the person placing the tag on the vehicle, and that's not included in this.
Ms. Kennedy Swanson.
He has no objection to ROR as to count 3.
Court will find no probable cause based on argument on count 3 only. He'll be ROR'd as to counts 1 and 2. Bonds are set in the amount of $500 as to count 1, $250 as to count 2, and I appoint the Office of the Public Defender to represent his interests.
He's not gonna ROR you on all counts here, or you on one count. You gotta contact somebody for.
As a condition of bond, he's not to drive without a valid driver's license.
500 and 250 if you go through a bond.
God, I'm gonna be stuck here. I don't have it. My son got the money.
Okay, your son can bond you out.
No, but he's gotta mail it to me, and my daughter and my son got the money. They both got it.
They can contact the bondsman. They don't have to come to you. Contact the bondsman.
So I gotta stay here until this gets paid.
Oh, sorry. Sorry.
State of Florida versus Devon Leroy.
Found it.
Thank you. State of Florida versus Joe Neal Rodriguez. Thank you. State of Florida versus Harry Brokenborough. Let's keep it going. State of Florida versus Bryant Burnett. Mr. Burnett, good afternoon.
Good afternoon.
You're here based on an allegation of trespass on property after warning.
He offers adjudication credit for time served, no return.
You wanna take that? You wanna take that, right? Credit time served?
Yes, sir.
All right. Burnett, we're going to swear you in.
Raise your right hand, please. Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
Mr. Burnett, that document you just signed indicates to me that you wish to plead no contest to the charge of trespass on property after warning. That's a first-degree misdemeanor. Is that what you wish to do?
Yes, sir.
You understand that you have a right to have a jury trial as to that allegation. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of the offense that you were charged with. At that trial, your attorney would be with you, would be cross-examining the witnesses and examining the evidence against you. You'd have a right to present your own witnesses and evidence. Could have had your trial recorded and appealed any error that occurred in that process. Do you understand by pleading no contest, you give up your rights to have a jury trial? And I'm going to go along with the state's recommendation. You understand all that?
Sir.
Anyone forcing you or pressuring you into making this decision? Anybody make any promises?
No, sir.
Under the influence of any alcohol, drugs, or mental issues that cause you not to understand what we're doing?
No, sir.
I find that you appear to be alert, intelligent. You've had an opportunity to think about the decision and discuss it with your attorney briefly. I find that there is a factual basis with which the court can accept this plea. Court will, is this an adjudication or a withhold?
I believe it was adjudication, Your Honor.
Adjudicate you guilty of trespass after warning. Sentence you to the time you've already served,
2 days.
which is 2 days. You'll be responsible for some court costs. I'm going to give you a period of 24 months to make these payments to the clerk of the court. If you don't make your payments, they could request to suspend your driving privileges. Do you understand?
Yes.
Madam Clerk, those court costs? It's $273 that you owe back to the state of Florida. You are agreeing not to go back to wherever this was that you weren't supposed to be, which is 7209 South Orange Blossom Trail. I don't know what's there, but you definitely have a trespass warning there, and if you show up, they're going to arrest you again, okay? Good luck. 30 days to appeal. If you wish to appeal, you must do it in writing. State of Florida versus Angel Correa. Is it Correa or Correa?
Correa.
Correa. Mr. Correa, you are here with us based on an allegation of resisting an officer without violence. I do find probable cause for your initial arrest. We'll set bond the amount of $250 and appoint the Office of the Public Defender. Thanks.
You're gonna have bond.
And the offer for Mr. Ash Jean is adjudication of guilt, credit for time served, no return.
He wishes to plea, Your Honor.
Next one. That was not this gentleman. That was on
Oh,
Mr.
okay.
Jean's case.
Oh, okay, I apologize, Your Honor.
Yeah.
They're not gonna let you resolve it today. Okay. Fine. Mr. Jean would like to resolve the case as well, Your Honor. Sign right there. Yep. Just what we talked about, credit for time served. It was credit for time served on Mr. Jean's case, right?
That's correct.
Okay.
Mr. Jean, we're going to place you under oath.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Did you hear Madam Clerk okay?
He said I do.
Okay. We just didn't hear you.
Say yes.
Yes.
You can put your hand down, Mr. Jean. Mr. Jean, are you good in English?
Yes.
All right. Mr. Jean, I just watched you sign this document. What it tells me is that you wish to plead no contest to one count of trespass. Is that what you wish to do?
Yes.
It's a first-degree misdemeanor allegation. You have a right to have a jury trial. At the jury trial, the state of Florida would have to prove to a jury that you committed the offense at the jury trial. You'd have an attorney with you. They'd be talking to witnesses and examining evidence against you. You understand you've given up all your rights to have a trial, because if I accept your plea of no contest, I'm going to sentence you to what the state recommended. We're not going to be having a trial. You understand that?
Yes.
Is anyone forcing you or pressuring you into making this decision?
No.
Anybody make any promises other than what's written on the form? Under the influence of any alcohol, drugs, or mental issues?
No.
Court finds that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss it with an attorney. The court will accept your plea of no contest to trespass after warning. You'll be adjudicated guilty, sentenced to the time that you have already served.
2 days.
Just 2 days. It's going to be some court costs you would be responsible for. I'm going to give you a period of 24 months to make those payments. If you don't pay, they could request to suspend your driving privileges. Do you understand?
Yes.
Madam Clerk, is it 273? Your court costs are going to be $273. 30 days to appeal. If you wish to appeal, you must do it in writing. Good luck.
Thank you.
State of Florida versus Joseph Genovese. Mr. Genovese, good afternoon.
How are you, sir?
I'm well, thanks for asking. Mr. Genovese, you as well are here based on an allegation of trespass on property after warning.
He offers credit time served, Your Honor, and he indicated earlier he'd like to resolve it.
Okay.
You still want to do that,
He was here 2 days, no, he was here last week. I'm not accepting a time served offer.
It's not going.
Court finds probable cause on trespass on property after warning, sets bond the amount of $500, and appoints the Office of the Public Defender.
You got to bond out.
Thanks. This last conviction was on September 20th. State of Florida versus Amari Lloyd. Mr. Lloyd, good afternoon. Mr. Lloyd, you were arrested based on an allegation of possession of cannabis under 20 grams. I do find probable cause. Set bond in the amount of $250 and appoint the Office of the Public Defender. You're also out on bond on aggravated assault with a deadly weapon. That's on case 2022 CF 7679. State, what's the request?
State's gonna have no objection to no action on the out on bond and just stay the bond on the possession of cannabis. I won't ROR him, which we would have normally done because he's out on bond, but.
Mr. Lloyd, you're out on bond on a very serious case. You can't have weed unless it's legal. Do you understand?
Understand now.
You don't understand? You do? Okay. All right. I'm going to take no action on the other bond and leave you out on bond on that case. I don't find that this is an allegation that involves violence. So I'm going to take no action as to 2022 CF 7679, but you have to stay within the bounds of the law, okay?
Sir.
Good luck. State of Florida versus Javion Upshaw. Mr. Upshaw, good afternoon. Mr. Upshaw, you are here based on an allegation of trespass other than a structure or conveyance refusal to leave. Looks like you were sleeping in Eola. You weren't very nice to law enforcement officers either, apparently. The court finds probable cause for your arrest and will set a bond in the amount of $150. I'll lower your bond. You're also out on bond on a petty theft allegation in 2022 MM 6247. State. Any requests?
I can make a global offer and get yelled at by Madam Clerk probably, but I can do an adjudication of guilt, credit for time served, no return. Cost investigation of 100 on the out on bond. There's a cost investigation of $133 even, and looks like restitution in the amount of $11.07.
Yeah.
And then time served and no return as well on the new law offense.
You would like to do that, Your Honor, if you just give me one moment to.
So that's a restitution of $11. And
Let's hold on to Mr. Upshaw. Mr. Upshaw, stick with us in the back, and I'll bring you up when your paperwork is ready to go. Mr. Rhodes, are you done talking with the state?
I am, but I think Ms. Kennedy Swanson is doing research.
Okay. All right. You guys let me know when you're ready. Yes. Good afternoon, Mr. DeLeon. Mr. DeLeon, you're here based on a new allegation. It's an out-of-county warrant. The out-of-county warrant is from Polk County. Alleges some very serious allegations of first-degree murder and tampering with evidence. You're on no bond out of Polk County. You're going to remain on no bond. And Polk County will be noticed that you are here with us. You are also out on bond on one of our cases in 2022, CF 7732. The court's going to find there's probable cause to believe you committed a new law offense while you were out on bond. Revoke your bond in that case, and bond in that case will be set in the amount of none as well. As to our case, 2022, CF 7732, the Office of the Public Defender is appointed if they weren't previously appointed. Thanks. State of Florida versus Celio Flores. Mr. Flores.
Oh, no, I'm Penzati.
Do we know what happened to Mr. Flores?
I can give the booking.
He's a Seminole County warrant.
It's 220222678.
Mr. Penzati,
Yes,
good
sir.
afternoon.
How are you doing, sir?
I'm well, thanks for asking. Mr. Penzati, you are here with us based on an allegation of an out-of-county warrant. That warrant is out of Polk County. I'll share with you as much information as I have.
Yeah, I don't remember the charge or anything. So
Yeah.
they come at a hotel at a water park and said I wanted to kill somebody. I said I don't even talk like that, but I
All right.
understand.
Mr. Pizzotti,
sir.
I don't want you to say anything. You're charged with, the allegations are domestic violence, aggravated stalking, and written threat to kill or injure. I don't want you to say anything that's recorded.
Yes, sir.
Because I'm not your trial judge and I can't help you much as to the facts of the case.
I understand. My mom worked at the public defender's office for 30 years, so I kind of know how it goes.
Yes, sir.
I'm not a bad criminal, so I'm just trying to behave.
Understood. Well, let me let you know that the case number out of Polk County is 2022 CF 7717. We'll let Polk County know that you're here with us.
Yes, sir.
You have no bond on count one. You do have a $5,000 bond as to count two. So Polk County will come get you and you can sort that out with them.
You know how long that would take by any chance? And do you know if Polk County would offer a bond, or is that something that don't bond out at all? Is it on no bond because I'm not there?
I don't know. It's probably, they need some input from the alleged victims and need probably an evidentiary hearing before they can make those determinations. I can't do that from here.
No, I
because
understand,
it's
but I know
their
if that was
warrant.
something that they do give a bond eventually, if, I want to.
I don't want to give you a number because I'd be just making it up. So we'll let them know that you're here with us, and I anticipate it won't be too long before they come get you.
Thank you, sir. I appreciate
Thanks.
it.
And Your
Need me
Honor,
for anything
you
else, or I'm
had-
done?
Hold on just a
You
sec.
had a no bond on count one and count two, the
$5,000.
$5,000.
Correct. Yep, you're all good. Thanks. State of Florida versus Elven Caban.
I think we addressed him yesterday, Your Honor. It might have just been added on in
I
error.
found PC for theft.
yeah.
It was a refusal.
And I think he set a bond. I think it was $1,000.
Refusal
was-
waived appearance, so this one might just got put in the pile by mistake. But he has a bond of $1,000 and the court accepts that waiver.
I think it was an issue where you were going to have him reappear today, Your Honor, and then you changed.
I did.
mind.
Yeah, we were gonna drag him into court and I just decided that that was, not fair for the corrections personnel, so I withdrew that order.
So we're keeping it at 1,000.
Yes. State of Florida versus Demion Davis. Mr. Davis, good afternoon. Mr. Davis, you are with us based on an allegation of possession of drug paraphernalia, resisting an officer without violence, and trespass on property after warning. I don't know what this is. Is he out on bond on the case?
He's out on ROR.
You're unfortunately out on release on another case. That's a drug-related offense of possessing cocaine in 2022 CF 5003. Court finds probable cause of the new offenses. Bond will be set in the amount of $500 as to each count. I'm going to revoke your ROR status. Issued no bond on 2022 CF 5003. Let's see. Hold on just a sec. Let's see how bad your record is. Bad. All right. Thanks. So you're on no bond on the old case, and you have bonds on the new case. I'll appoint the Office of the Public Defender to represent you on all your cases. Thanks. State of Florida versus Brandon Harris. Okay, he's currently on a no bond based on not my warrant, based on an arrest. We reset him from yesterday. He's charged with 7 serious counts with victims. We're going to reset Mr. Harris.
What was the reason?
Mental health. State of Florida versus William Matthews. All right, the court's going to find that Mr. Matthews has refused to join us. This was a reset from yesterday. Court's going to find that is an indication that he is waiving his opportunity to participate in initial appearance. I'll appoint the Office of the Public Defender on this case, find an on-view violation of probation. In case number 2020 CF 12273, bond will be set in the amount of none. As to the new law offense, but court finds probable cause in, let's see. he have multiple VOPs?
Yes, he has 5.
Okay, he's got 12273. He's got 11138. That is the new law offense. The court finds probable cause and issues a bond in the new case in the amount of $3,500 as to 2020 CF 12506. The court finds an on-view violation of probation based on probable cause of the new offense. 2020 CF 12506. Court finds an on-view violation of probation, sets bond the amount of none on the on-view violation based on the PC on the new law offense. So on the VOP's on-view, bond is set at none. On the new law offense, bond is set in the amount of $3,500.
And then he has 2.
State of Florida versus Bernard Norris.
Excuse me, Your Honor. He has 2 warrants for the VOPs as well. Are you keeping those at 9?
Oh, is this still Mr. Norris?
It's on Matthews, right?
Is this a new law offense or is this a VOP? This is the new law offense on Mr. Norris. Right. Where's Bernard Norris? All right. Court's going to be forced to reset Mr. Norris's case for mental health. Officer, you said there was an issue with the last one?
Yes. He had 2 warrant VOPs, so you did the on-view VOP and the new law violation.
Right, I addressed 2020 CF 12273, that's an on-view VOP, no bond. I addressed 2020 CF 12506, that's an on-view violation, no bond. I addressed 2020 CF 12506, oh, that's the same paperwork.
But there are warrants. One was 2 were on-views and the other one were warrant VOPs. So you didn't address the warrant VOPs.
Oh, okay. I don't know if it, I guess he's got a warrant on which case, 12506?
Yes, both are the VOPs that were on-views. He has warrants for those as well.
Okay. Judge Tarlika Navarro has found probable cause for his violation of probation. He's going to be no bonded on both of his violation of probation allegations. Tamarcus Reynolds. This is a reset from yesterday. Court's going to find a continued refusal for Mr. Reynolds, indicates that he's not interested in joining us for initial appearance. The court will make a finding of probable cause, appoint the Office of the Public Defender. Court's going to set bond the amount of $10,000 plus the conditions that he not have any contact with the alleged victim. Vanessa Santiago, and that he not return to the 7-Eleven at 476 North Orange. Kenny Swatson, are you getting close to needing a break?
Nope.
State of Florida versus Timothy Taylor. Good afternoon, Mr. Taylor. Mr. Taylor is with us based on an allegation of possessing cocaine. I do find probable cause for that allegation. Will set bond the amount of $1,000 and appoint the Office of the Public Defender. He's also out on bond, unfortunately, on 2022 CF 5782. Court's going to, he's out on ROR. The court's going to revoke his ROR status. And he's out on ROR on 2022 CF 7897. Court's going to revoke his ROR status. Bonds on those cases will be set in the amount of none, based on there being probable cause that he committed a new law offense while out on release. Thank you. State of Florida versus Danielle Dunlap. Ms. Dunlap, you are here with us based on an allegation that you violated probation in 2020 CF 4307. You were arrested pursuant to a warrant by Judge Wooten, who issued no bond. You're going to remain on no bond till you get in front of him, and I will appoint the Office of the Public Defender to represent your interests. State of Florida versus Narkeith Payne. All right. Mr. Payne was arrested based on a violation of probation warrant. PC's already been found. The court will appoint the Office of the Public Defender. Find Mr. Payne is not interested in joining us for initial appearance. He'll remain on no bond until he can get in front of Judge Strobridge. That leaves our plea and Mr. Rhodes' case.
Can we talk about Mr. Rhodes' case while defense is going over the plea form with the defendant?
Sure. Good to go on, Mr. Upshaw?
Yes, Your Honor.
All right, thanks. Mr. Upshaw, I've just been handed a document, looks like this. It's a plea form. The document tells me that you wish to resolve two cases. Those two cases are 2022 MM6533 and 2022 MM6247. By pleading no contest to those allegations, is that what you wish to do?
Say it out loud.
Yes, sir.
You understand as to both of those allegations, the allegation in 2022 MM6247 is petty theft. The allegation in 2022 MM6533 is trespass other than a structure or a conveyance, both nonviolent, low-level misdemeanor offenses. If you wish to plead no contest to those charges, the state of Florida is inclined to offer you the credit for the time that you have already served to order restitution in the petty theft case. You won't be able to return to the store where that is alleged to have occurred. And a cost of investigation, the amount of $133 to the Orlando Police Department. You understand that that would be the imposed sentence?
Yes, sir.
You understand as to both of those allegations, you have a right to have a jury trial. And at the jury trial, the state of Florida would have to prove to a jury, beyond and to the exclusion of every reasonable doubt, you committed each element of the offenses that you were charged with. At that trial, your attorney would be with you, would be cross-examining witnesses and examining the evidence against you. You would have a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have testified at your trial or remained silent and not testified. That would have been your decision after you talked those decisions over with your attorneys, and your juries would have been instructed not to consider that decision in any way in rendering verdicts. You would have had a right to have the trial recorded and appeal any error that occurred in the process. Do you understand you are giving up all of your trial rights? Because the court accepts this plea on these two cases, I will go along with this recommended sentence, and we will not be having trials in these matters. Do you understand those things? Is anyone forcing you or pressuring you into making these decisions? Has anyone made you any promises other than what is written on these plea forms, or this plea form? Court finds that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss this decision with your attorney briefly. Are you satisfied with her help? Satisfied with Ms. Lamphere? She worked you out a phenomenal deal in about 10 minutes, so I think you should be.
Are you happy with how I represent?
Okay. Court finds that based on your responses, you appear to be alert, intelligent. You've had an opportunity to think about this decision, and you're doing so of your own free will. Court accepts your pleas as to 2022 MM6247 and 2022 MM6533. You'll be adjudicated guilty of both of those offenses. As to 2022 MM6247, you're sentenced to the time that you have already served. Does anybody have that amount?
8 days.
8 days. That is to be followed by you paying restitution in the amount of $133. State, do we have a restitution order?
No. It's cost investigation is $133. Restitution is $11.07.
Sorry. Do we have a restitution order for
I
$11.07?
gave the address to the clerk a moment ago, Your Honor, for the restitution.
Okay. All right, restitution is going to go to the address provided to Madam Clerk in the amount of $11.07. You owe a $133 cost of investigation to the Orlando Police Department. There's going to be court costs on that case as well. $273. You owe $323 as in court costs as to that case. In 2022 MM 6533, you'll be adjudicated guilty. You'll be sentenced to the time that you have already served on that case,
2 days.
which is 2 days. There's going to be some court costs that you owe on that case, $273. I'm going to give you a period of 36 months to make all your court cost payments to the clerk of the court. You can make little tiny payments, but make payments. If you don't make any payments and they can't find you, they could request to suspend your driving privileges. Do you understand?
Sir.
Any money that you pay will go to restitution first. You have 30 days from today's date to appeal these judgments and sentences. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you.
What's the restitution for?
The items stolen were,
Is there a name?
oh, I'm sorry to put the name on there. I apologize. I'll walk that back up, Madam Clerk.
All right, as soon as we can, the place where you need to pay the restitution will be on your paperwork. Thanks.
You're all set.
I've done the order, but
Forward, Ms. Acevedo came in under a Baker Act, therefore defense would be requesting for her to be ROR'd.
These are nonviolent traffic offenses.
No objection.
Thanks.
Your Honor, I did not get the appearance of the state. I'm sorry, who's present on behalf of the state?
Kathy Kennedy Swanson.
Thank you, ma'am.
Ms. Acevedo, you're here with us based on allegations of attaching a tag not assigned and driving with an expired tag over 6 months. I do find probable cause for those allegations. We're going to release you ROR so you can get some help. These are nonviolent second-degree misdemeanor traffic violations. So you'll be seen by some medical personnel, and I will appoint the Office of the Public Defender to represent your interests. When and if these cases are filed, they're going to be mailing some paperwork to you. Current address I have is Knights Inn. Is that where you're still at?
Yeah.
Okay. Where your paperwork's going to go. If you move, you need to update the clerk's office. If they mail paperwork and you don't show up because you didn't get it, they could issue a warrant for your arrest. I'd hate to see that happen on these types of charges. You understand?
Your Honor, she said yes, but I had her muted. I apologize.
Good luck to you, Ms. Acevedo. Thanks.
Thank you, ma'am.
State of Florida versus Brittany Joseph.
Present and approaching.
Ms. Joseph, good morning.
Judge, there is a victim, I believe, here. Joseph case.
Thanks. This is right in the way. All right. Good morning, Ms. Joseph. There is a witness present. I'm going to get some information.
McKenzie.
Please raise your right hand.
I'm Mr. McKenzie.
You're Mr. McKenzie?
Yes, sir.
All right. Listen to the clerk's instructions.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Joshua McKenzie.
May I inquire, Your Honor?
Yeah.
Mr. McKenzie, how do you know Miss Joseph?
That's my baby mom.
I can't hear you, Mr.
My
McKenzie.
baby mom?
Are you afraid of her?
No.
Would you like for her to be allowed to have no hostile or nonviolent contact with you while this case is pending?
Meaning,
I can't hear you. Can you speak a little closer?
meaning what? What's that?
Meaning, she'll be allowed to have contact with you while this case is pending. Is that what you would like?
Yes, ma'am.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
Has anything like this happened in the past?
Nothing violent, no.
No further questions, Your Honor.
Ms. Lanfear, any questions?
No, Your Honor, I know.
Oh, I'm sorry. Mrs. Scardo, any questions?
No, Your Honor.
I can see him now. Yeah, I can see him down there. Just a little bit, be good. Perfect, that's perfect. All right, based on the court finding probable cause and based on the sworn testimony of the alleged victim, the court is going to set a bond in the amount of $250 plus pretrial release conditions. Those release conditions are going to be that you have no hostile contact, ma'am, with your significant other, Mr. McKenzie. Mr. McKenzie, do you guys live together?
We're homeless.
You're homeless? Where are you staying now?
We stay in hotel rooms.
Okay.
Yes, sir.
So you're in a hotel room?
Yes, sir.
All right. Do you have any fear of Ms. Joseph coming back to the hotel?
No.
Are you guys didn't get trespassed or anything, right?
No.
Okay. Ms. Joseph, the court's going to allow you to return to the hotel. You're to have no hostile contact with Mr. McKenzie. And the court will appoint the Office of the Public Defender if I didn't previously announce that.
We'd ask for no weapons and firearms, Your Honor.
As a standard condition of pretrial release, Ms. Joseph, you're not to possess any weapons or firearms. Thank you.
Thank you, Your Honor. Have a seat, ma'am.
State of Florida versus Muad Kamlichi.
President approaching.
Mr. Kamlichi, am I pronouncing that correctly?
Yes, sir.
Mr. Kamlichi, you are here with us based on an allegation of fleeing or attempting to elude a law enforcement officer with lights and sirens. I do find probable cause for that allegation. I'm going to set bond in the amount of $3,500. You're also out on bond on 2021 CF 2895 for a similar offense. I'm going to revoke bond on that case, finding that there's probable cause to believe you committed a new felony while you're out on felony bond. Your bond will be set in the amount of none, and I will appoint the Office of the Public Defender to represent your interests. Thanks. He's got two cases. Hold on just a sec. You also have a charge of resisting an officer without violence. Court will find probable cause, set a bond in the amount of $500 on that case.
Thank you. Have a seat, sir.
State of Florida versus Blaine King.
President approaching.
There's a victim here, Your Honor, on the King case as well.
Morning, Mr. King. Mr. King. There's a witness present. I will appoint the Office of the Public Defender to represent your interests and find probable cause for the allegation, which is an allegation of aggravated battery upon a pregnant person. Ma'am, good morning. Please follow the clerk's instructions.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
Kaylin Bronson.
I'm having a really tough time hearing you, so if you could speak,
Sorry.
you can grab that microphone and bend it down towards you.
Yeah. Kaylin Bronson.
Thank you, Ms. Bronson. Ms. Bronson, you are listed as the alleged victim in the charging affidavit. I'm going to be making some decisions this morning as to whether it's appropriate to have contact with Mr. King and whether it is appropriate to have Mr. King return to the family home if you guys live together. Do you wish to give me any information about that?
I would like him home. I feel like it was very misunderstood. I'm so sorry. I feel like the whole situation was misunderstood. I mean, my family doesn't get along with him. I want him home. I'm not fearful of him at all. We own a business together. I miss him already.
All right, thanks. In just a moment to read the charging affidavit again. Dante, was the minor child the complainant?
Looks like I thought it was a witness.
It says complainant slash juvenile witness.
Can I inquire of the victim, Your Honor?
Yes.
Ma'am, is the minor child, does he live with you guys as well, the 13-year-old?
No.
And so if the defendant was allowed to return to the residence, the 13-year-old would not be there?
No. I mean, no.
Your Honor, I apologize. Defense is having a difficult time hearing.
Yeah.
Oh, sorry.
You need to speak up nice and loud for us.
No, he won't be there. He was visiting.
Okay. No further questions, Your Honor.
Ma'am, where does Chase live?
With my stepmother.
Is this Skiddo? Any questions?
Ma'am, if Mr. King, do you and Mr. King reside together?
Yes, we do.
Okay. Would you like him to return home?
Of course, yes.
Okay. If a situation arises where you feel you're not safe, would you call 911?
Yeah, if I felt threatened in any way, I wouldn't second guess that.
Okay. Thank you. No further questions.
Officer Jenkins, is there prior criminal history?
From 2017 on to now, he just had possession of marijuana, no valid driver license.
Ms. Bronson, you're in the best possible position to gauge your concern about the incidents that happen. I've got continuing concerns. Court's going to do this. The court is going to allow you to have allow Mr. King to have non-hostile contact with you. Court is going to impose as a condition of bond in the amount of $500 plus pretrial release conditions that you are to maintain separate residences for the time being. You can petition your trial judge with additional information, and your trial judge can make a determination as to whether that's a good idea. But at this point, you're going to maintain separate residences. I'll allow Mr. King to return one time with law enforcement and get some personal property while this case is pending. So you can have contact with him, but he's not going to be allowed to live there until further court. Thanks. State of Florida versus Treat.
Your Honor, I apologize, but Mr. King would like to ask the court if the court would reconsider the maintaining separate residences. He advised that he's the primary financial provider and that he has no other place to go, and the property that they're currently in, they're renting.
I understand. He's still financially responsible. But no, I'm not going to revisit that. He can, he's represented by the Office of the Public Defender. They can set an evidentiary hearing in front of the trial judge, which could be me, or Judge Nix, or Judge Young, and they'll be able to revisit that decision.
Thank you, Your Honor. Have a seat.
Thanks. Tyree Dante Lattimore.
Present and approaching.
Sir, you are here with us on two separate allegations. They were filed separately. The allegations are possessing cocaine, possessing drug paraphernalia, and battery, domestic related. I've taken a look at the charging affidavits. I do find probable cause for each of those allegations. We'll appoint the Office of the Public Defender on the new cases to represent you. Unfortunately, you're out on bond on 2022 CF 9493. Court has probable cause to believe you have violated the law while you're out on that bond. The court's going to revoke your bond on 2022 CF 9493. That's out of Orange County. Bond currently will be set in the amount of none. I'll appoint the Office of the Public Defender on that case as well. If they weren't previously appointed, they can get you in front of Judge Calderon. You can explain to him what's going on. Thanks.
Your Honor,
Hey.
Mr. Lattimore would like to ask the court if the court would reconsider and set bond as ROR.
We're not going to do this on every case. If you have a legal reason to make the request, Mrs. Skirdo, I'm happy to hear it. Otherwise, that'll be the ruling of the court.
Thank you, Your Honor. And on the possession of cocaine, what was the bond amount?
The bond amount on the possession case is $1,000. On the paraphernalia, it's $500. On the battery charge, the court's going to set bond the amount of $1,000 with the conditions that he have no contact with the alleged victim in the case, and that would be good Lord. State, can you find a name?
Alicia Jenkins. On the warrant paperwork, it have Alicia Jenkins.
All right, thank you. That was pursuant to warrant, so that would be Alicia Jenkins. And I can't tell whether this occurred at the home or not, so that will be the only condition of bond.
Thank you, Your Honor. Have a seat,
Thanks.
Mr. Lattimore.
State of Florida versus David Antonio Marrero Mendez.
Your Honor, Mr. Mendez is in the hospital. May we reset him until tomorrow?
Yes, or I'll appoint the Office of the Public Defender and you can waive. He's entitled to bond.
Your Honor, I'll go ahead and waive.
Court will appoint the Office of the Public Defender on Mr. Marrero Mendez. The court finds probable cause for the following offenses: driving while license suspended, attaching a tag not a sign, driving with no registration, and misuse of a temporary tag. Bond is going to be reduced on the Dwellis to $1,500. Be set in the amount of $250 on the attaching tag not a sign. No registration on the will be $250, and misuse of the temporary tag will be $250. What's that? I guess he has another traffic charge. That's an.
Yes, Your Honor, operating motor vehicle without valid driver's license.
I will be set in the amount of $250 as to that charge.
Thank you.
Court finds probable cause. State of Florida versus Michael McMahon.
Your Honor, he's in detox and he advised he wanted his appearance waived, so defense will proceed.
Court will accept the waiver, appoint the Office of the Public Defender, find probable cause for resisting an officer without violence, set bond the amount of $500. He is not to possess or consume any illegal substances as a condition of his bond. State of Florida versus Hector Morales.
Present and approaching. Hector?
Mr. Morales, you were arrested for the allegation of DUI. Do you find probable cause for that allegation? We'll appoint the Office of the Public Defender to represent you. Your bond is set in the amount of $1,000. Nope. Hold on just a sec. Looks like you qualify for pretrial release. I'm going to release you on pretrial release with the special condition that you not drive without a valid driver's license and that you consume no alcohol. Thanks.
Your Honor, that's bond and PTR, correct?
Negative, straight PTR.
Oh, straight PTR. Okay, thank you, Your Honor.
State of Florida versus Yamilet Ortiz. Is there a witness present?
No, Your
And Your Honor, Ms. Ortiz is in the cage. She's being brought forward. Also, while she's being brought forward, Ms. Ortiz is here on a Baker Act. Would the court consider RORing her?
No, this is an allegation that,
I apologize, Your Honor. She's not on a Baker Act.
yeah, okay. And then, Ms. Ortiz, you are here based on an allegation of battery domestic violence related. I do find probable cause for the allegation. I will appoint the Office of the Public Defender to represent your interest. I've got no additional information, so the court is going to impose a bond in the amount of $1,000 with these special conditions that you have no contact with Lisette Plowed, and you're not going to be able to go back to the Nano Street apartment. Court will allow you to return one time with law enforcement to get some personal property while this case gets sorted out. Thank you.
Your Honor, Ms. Ortiz would like to speak to the court. I did advise her anything she says can and will be recorded and used against her.
Sure. Ms. Ortiz, whatever you say is going to be recorded. You are represented by an attorney. She's advising you not to talk about the facts of the case because that might put you in a worse position. But I'm not going to shut you down. If you want to speak to me, I'll hear you out.
I was just going to dispute the eviction that was pending. I know that you stated that I have to leave the premises. However, I would like to extend the stay just until I am able to find somewhere else to go.
I understand. I understand that this is a hardship. Court's going to not allow you to return to that location. This looks like Mom's house. So for the time being, you're not going back there. I will allow you to return one time with law enforcement to get some personal property. You can petition your trial judge for a change in this order, but this is going to be the order for now. Thanks.
Have a seat, ma'am.
State of Florida versus Javier Ramos.
You after, okay?
State of Florida versus Javier Ramos Perez.
President approaching, Your Honor.
Thanks. Mr. Ramos Perez, you are with us based on an out-of-county warrant. That warrant's out of Pasco County. Looks like, if I had to guess, a failure to appear warrant. Looks like the underlying offense was driving while license suspended. You do have a bond. Your bond is in the amount of $513. If you decide not to post your bond, we'll let Pasco County know that you're here with us. Thanks. State of Florida versus Jose Rodriguez.
President approaching.
Thank you. Good morning, Mr. Rodriguez. You're here with us on a allegation of petty theft, third or subsequent offense, and trespass in a structure. Court finds probable cause for that allegation. Court's going to set bond. I'm going to raise bond in count one, the amount of $2,500. Bond will be stayed in count two in the amount of $500. I'll appoint the Office of the Public Defender to represent your interest. Thank you.
And Your Honor, Mr. Rodriguez advised he would like to speak to the court. I did advise him anything he says can and will be used against him.
Sure. Mr. Rodriguez, what do you want me to know?
I just Park Place yesterday, and I was under new medications. I was there for, I think, 5 or 6 days. I'm the primary caregiver of my mother. My family's military. She has epilepsy, and I'm the only person that takes care of her. And the storm is about to hit tomorrow night. I'm asking for ROR.
Your request is denied. Sorry that your family's struggling, but I've got probable cause to believe that you once again have committed a theft. Any mental health related issues, your attorney will be able to bring those in front of your trial judge.
Thank you, sir. Have a seat.
State of Florida versus Rodriguez Colon.
President approaching, Your Honor. He's in the cage. And, Your Honor, while Mr. Rodriguez Colon is coming up, he came in on a Baker Act. Therefore, defense would be requesting if the court would consider ROR.
Officer Jenkins, can you give me some background information?
He have no prior arrest, Your Honor.
One.
But mental health, they'll bring paperwork. They will be Baker and acting him, so we were trying to get ROR for him.
I understand. The danger with ROR is that he's under no conditions of release whatsoever. So as soon as he's cleared from the Baker Act or the mental health facility, he's just out there with no conditions.
Okay.
Would he ordinarily qualify for pretrial release if there weren't these concerns?
Yes, sir.
State, do you have a position?
No, Your Honor, we're leaving the court's discretion.
I don't know enough about Mr. Rodriguez Colon's prior criminal history to make a determination as to whether ROR is appropriate. Take a look at the charging affidavit. I find probable cause for the allegations and why he's here. That was a charge of possession of less than 20 grams of cannabis, possession of drug paraphernalia, and resisting an officer without violence. Court's going to set bonds in these cases. Bond in count 1 is going to be set in the amount of $250. Bond in count 2 is set in the amount of $100. Bond in count 3 is set in the amount of $250. I'll appoint the Office of the Public Defender to represent his interests. Thanks.
Thank you. Have a seat, sir, okay?
State of Florida versus Jared Rudolph.
President approaching.
Mr. Rudolph, good morning.
Good morning.
I'm good. Thanks for asking, Mr. Rudolph. Mr. Rudolph, you are here with us based on an allegation of trespass. I've taken a look at the allegation. Do you find probable cause for your arrest? The court's going to appoint the Office of the Public Defender. I'm going to release you on pretrial release. As a condition of your pretrial release, you're not to go back to the store, and that is the Wawa at on West Vine Street. Can't go back there as a condition of your release. Do you understand?
Your Honor, I had him muted. He said yes, sir.
All right, thank you. If I didn't previously announce it, I'll appoint the Office of the Public Defender.
Thank you, Your Honor. Have a
Thanks.
seat, sir.
State of Florida versus Andrew Scott Martinez.
Your Honor, he wanted his appearance waived, so defense is proceeding.
Thank you. The court will accept the waiver of his appearance. Appoint the Office of the Public Defender. The court finds probable cause for criminal mischief of $200 or less and resisting an officer without violence. Bond in count 1 set in the amount of $250. Bond in count 2 set in the amount of $500. Thanks. I'm going to try and get the interpreter on board.
Thank you, Your Honor.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning, Mr. Morales. We are doing initial appearances. The first 3 of those folks will be out at the Osceola County Jail facility. First one that I have is John Doe 3221.
President approaching.
Thank you. The agency case number, Mr. Morales, is 2022 I-103026.
Thank you, Your Honor.
Thanks. Good morning, sir. Can you tell me your name, please?
Buenos días, señor. Por favor, ¿podría indicarme su nombre despacio y en voz alta, por favor?
¿Usted escuchó el intérprete?
No.
Por favor, hable despacio y dígale su nombre a la corte.
Cristian Yair Hernández García.
Christian Yair Hernandez Garcia.
Sí.
Right. The court is going to appoint the Office of the Public Defender to John Doe 3221, a.k.a. Mr. Hernandez Garcia.
Este tribunal va a designar a la Oficina de Defensores Públicos para representar a John Doe 103026, también conocido como Christian Yair Hernández.
I see that there has been an effort to identify this gentleman. Was he actually identified?
No, sir.
Veo que han habido esfuerzos para identificar a este caballero. ¿Acaso ha podido ser identificado este caballero? No, señoría.
I've got no information to verify that Mr. Hernandez Garcia is who he says he is.
No cuento con información adicional para verificar que el señor Cristian Hernández sea la persona que dice que es.
Court is going to continue to hold him without bond until he is positively identified.
Este tribunal continuará sujetándolo sin fianza hasta poder identificarlo apropiadamente.
The court will reset his initial appearance until tomorrow.
Vamos a aplazar su comparecencia inicial para el día de mañana.
Thank you, Your Honor.
Thank you.
Tienen que esperar a que la agencia sea la que lo identifique a ustedes. So toma asiento.
Mr. Interpreter, our next case is John Doe 3222.
Cardosa, present and approaching, Your Honor.
Good morning, sir.
Buenos días, señor.
Puede hablar. Good morning. Puede decir good morning? Your Honor, I think he's just afraid and doesn't understand. I'm explaining to him. Puede decir
Understood.
buenos días.
Buenos días.
Good morning.
Sir, I do see that you have been identified after efforts as Martin de Jesus Cardoza Oliva. Is that correct?
Veo que ha sido identificado usted, señor, como Martín de Jesús Oliva. ¿Eso es correcto?
Sí, señor.
Yes, sir.
Sir, you were arrested based on two allegations. Allegation number one was grand theft firearm, and allegation number two was driving with no valid driver's license.
Señor, usted ha sido puesto bajo arresto por dos alegaciones. La primera es hurto de mayor cuantía mediando arma de fuego y el segundo es manejar un vehículo de motor sin licencia válida.
Find probable.
Sí,
I
señor.
find
Yo acababa de comprar el carro y aparece eso ahí.
Don't talk about, no hable sobre los hechos del caso, okay?
Okay.
Yeah, sir, your attorney is going to advise you not to talk about the facts of the case, even if you disagree with what's in the information. That needs to be a discussion you have with your attorney first.
Señor, su abogada le va a indicar a usted que no discuta los hechos del caso. Eso es algo que usted tendrá que hablar en su momento con su abogada en privado.
Court finds probable cause for those. Court finds probable cause for those allegations.
Determinamos que hay suficiente indicio de criminalidad para esas alegaciones.
Court will set bond as to the grand theft firearm charge in the amount of $3,500.
Se fija la fianza para la primera alegación de hurto de mayor cuantía por $3,500.
Bond is set in the no valid driver's license in the amount of $250.
Por la segunda acusación de no tener licencia de conducir válida, se fija la fianza en $250.
And the Office of the Public Defender is appointed to represent you.
Y además se le designará a la Oficina de Defensores Públicos para que le represente.
Thank you, sir.
Gracias, señor. Your Honor, may I have the case number for this defendant?
My apologies. Mr. Morales, the case number is an FHP number. It's going to be FHP 22O, N is in November, 0491439.
Thank you, Your Honor.
Yes, sir.
And the name provided by the FBI?
The court will find that he has been identified as the name pursuant to the FBI search.
Thank you, sir.
Thanks, Officer Jenkins. Mr. Morales, the next case that we have is Sayen Solis Reina Pascuala.
Present and approaching.
Good morning, ma'am.
Buenos días, señora.
Buenos días.
Good morning.
Ma'am, you were arrested based on an allegation of driving a motor vehicle without a valid driver's license.
Buenos días. Usted fue puesta bajo arresto bajo una alegación de conducir un vehículo de motor sin ser portadora de licencia de conducir válida.
The court finds probable cause for that allegation.
Este tribunal determina que hay suficiente indicio de criminalidad para esa acusación.
I'll appoint the Office of the Public Defender to represent you.
Designaré a la Oficina de Defensores Públicos para que le represente a usted.
I will reduce your bond to the amount of $250.
Se fijará la fianza en $250.
Thank you, ma'am.
Your Honor, she also has
Gracias,
a
señora.
resisting arrest without violence.
I missed it. Let me take a quick look.
También cuenta con una acusación de resistirse a la autoridad sin violencia.
Court finds probable cause for the allegation of resisting an officer without violence.
Este tribunal determina que hay suficiente indicio de criminalidad por acusación de resistirse a la autoridad.
Bond will be set in the amount of $250
Se fijará la fianza en $250
for a total bond amount of $500.
para un total de fianza de $500.
Thank you, ma'am.
Gracias, señora.
Toma asiento. Okay, gracias.
Mrs. Izquierdo, that was the last of the folks I had on my list. Do you have any clients that need to be seen?
No, Your Honor, that is all from Osceola this morning. Thank you so much.
Good morning. Thank you for your help.
Take care. Bye-bye.
And my apologies once again, Your Honor. Can I have the case number for Ms. Solis Pascual?
Of course. Case number is going to be an agency case number, Osceola County Sheriff's Office 22I-103026.
Thank you very much, Your Honor.
Thank you, Mr. Morales. We have a couple folks from the Orange County list that need your assistance. Can you hang out with us for a minute?
Certainly, Your Honor.
Mr. Morales, the first case that we have is Manuel Lucia Verez. The case number is 2022 CF 11177.
See? Your Honor, the interpreter can confirm there's connection to the headsets.
Thank you. Good morning, sir. You were arrested based on allegations of aggravated assault and battery domestic violence related. Court finds probable cause for those allegations. I will appoint the Office of the Public Defender to represent your interests. Court is going to set bond in count one in the amount of $2,500. Bond will be set in count two in the amount of $1,500. You will have a special condition of bond that you not have any contact whatsoever with Valentina Herrera. You will not be permitted to return to the Stallion Drive address. Do you need to return to that property one time with law enforcement to get any personal belongings?